Hey y'all, welcome back. So this is going to be Unit 3B, the right to privacy, and we'll talk about three cases. So the first is Griswold v. Connecticut in 1965. This is a 7-2 reversal of the lower court's ruling, and Justice Douglas delivers the majority opinion. So it's a case brought by Buxton and Griswold. Griswold is the director of the Planned Parenthood branch in Connecticut. And Buxton is a Yale medical doctor and a Yale professor of medicine. And they were both arrested for giving advice to a married couple on contraceptives. Um, and the court basically brings up a 14th Amendment due process clause argument, and they sort of touch on some of the former cases that we've talked about. So they say, there's um, that parents have a right to educate their children in the school of their choice. There is a right to teach foreign languages, as we talked about earlier. And so the sort of construction of these rights is what they're implying is that there doesn't have to be an explicitly stated right in the Constitution or in the amendments. Rights can exist outside of those that are laid out explicitly in the Constitution. And then they go on and say the right to freedom of speech and the press includes not only the right to utter or to print, but the right to distribute, receive, the right to read and freedom of inquiry, the freedom of thought and the freedom to teach, indeed, the freedom of the entire university community. Without those peripheral rights, the specific rights would be less secure. The present case then concerns the relationship lying within the zone of privacy created by several fundamental constitutional guarantees. And it concerns a law which, in forbidding the use of contraceptives rather than regulating their manufacture or sale, seeks to achieve its goal by means having a maximum destructive impact upon that relationship. Such a law cannot stand in the light of the familiar principle, so often applied by this court, that a governmental purpose to control or prevent activities constitutionally subject to state regulation may not be achieved by means which sweep unnecessarily broadly and thereby invade the area of protected freedoms. Would we allow the police to search the sacred precincts of marital bedrooms for telltale signs of use of contraceptives? The very idea is repulsive to the notions of privacy surrounding the marriage relationship. Okay. And then Justice Goldberg concurs and makes a really rare Ninth Amendment argument. And the Ninth Amendment states, quote, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So it basically just says, like, there are rights that exist out there that we haven't really thought about or written explicitly into the Constitution, and this Ninth Amendment protects those in the future. And so, excuse me, Goldberg goes on to say, the Ninth Amendment simply shows the intent of the Constitution's authors that other fundamental personal rights should not be denied such protection or disparaged in any other way simply because they are not specifically listed in the first 8 constitutional amendments. And I would note that one of the cases that we're going to read in the next section, the Dobbs case in 2022, took aim at this case specifically, and Clarence Thomas has been very sort of open about his dislike of the Griswold case. So that could be on the docket in the future. Okay, excuse me, I'm not feeling so well today. Case 2 is Eisenstadt v. Baird in 1972. 2 judges recused themselves, so it was a 6-1 affirmation of the lower court ruling, and Justice Brennan delivers the majority opinion. So Baird was arrested for discussing contraceptives and displaying them and giving a woman what was called at the time MCO vaginal foam, which was a foam contraceptive. It was like a spermicidal. um, it was against the law for anyone who was not a medical doctor to give out um, condoms or contraceptives, um, and you could only give them to married women. Okay, so Massachusetts Supreme Court. I'm sorry, there's a trash truck behind my house. Give me a second. Okay, that's better. Okay, so the Massachusetts Supreme Court basically overrules the arrest on the discussion and the display, but they do uphold the charges for having distributed the vaginal foam to the young woman. Baird files for a dismissal based on habeas corpus. Habeas corpus is comes from Latin. It means produce the body, and it is a fundamental right in the United States system that the state has to provide evidence against you, and if evidence does not exist, they have to dismiss the case. Um, so he wanted the case dismissed. His argument was dismissed by the district court, but the First Circuit Court of Appeals said he's got a point, so we're going to dismiss the case. And so the Supreme Court took it up upon appeal by the state. And so here's the setup of the basic law that was being argued in Massachusetts. There were basically, it was a 5-year sentence for distribution of contraceptives, which is kind of a lot, right? 5 years. Um, and there are three different, you can give out contraceptives if you're a doctor or a pharmacist, right? So just a lay person cannot. And there are three types under the law. Married couples can get contraceptives from a doctor or a pharmacist. Single people are not allowed to access contraceptives even under a pharmacist or a doctor. And married or single persons can obtain contraceptives for disease prevention, but not for contraception. Strange, right? And they quote, the legislative purposes that the statute is meant to serve are not altogether clear. And then they offer their ruling. They say the Court of Appeals concluded that the statutory goal was to limit contraceptive in and of itself, a purpose that the court held conflicted with fundamental human rights under Griswold v. Connecticut, where this court struck down Connecticut's prohibition against the use of contraceptives as an unconstitutional infringement of the right of marital privacy. We agree that the goals of deterring premarital sex and regulating the distribution of potentially harmful articles cannot reasonably be regarded as legislative aims. And we hold that the statute, viewed as a prohibition on contraception per se, violates the rights of single persons under the Equal Protection Clause of the 14th Amendment. The question of our determination in this case is whether there is some grounds of difference that rationally explains the different treatment accorded married versus unmarried persons under Massachusetts general law. For the reasons that follow, we conclude that no such grounds exist. First, whatever the rights of the individual to access contraceptives may be, the rights must be the same for unmarried and married alike, right? Due process. If under Griswold the distribution of contraceptives to married persons cannot be prohibited, a ban on distribution to unmarried persons would be equally impermissible. It is true that in Griswold the right of privacy in question inhered in the marital relationship. Yet the marital couple is not an independent entity with a mind and heart of its own, but an association of two individuals, each with a separate intellectual and emotional makeup. If the right of privacy means anything, it is the right of the individual, married or single, to be free from unwarranted governmental intrusion into matters so fundamentally affecting a person as a decision whether to bear or beget a child. Okay, so they basically just extend the Griswold finding to now everyone, right? Contraceptives can be distributed to all, regardless of your marital status. All right. Case 3, Casey versus the Population Services International in 1977. This is a 7-2 affirmation of the lower court ruling, and Justice Brennan delivers the majority opinion. So, there was a New York law that said, first, no contraceptives may be sold to minors under the age of 16 years old. Second, only a licensed pharmacist may distribute contraceptives to adults. And third, no one, even pharmacists, may display or advertise contraceptives. And the district court declared all three of those statutes unconstitutional. All right, so here's the context. PSI, Population Services International, sells and distributes contraceptives from North Carolina. They have like a little magazine leaflet that they mail out offering mail order contraceptive services. New York declares this illegal and, over numerous contacts with the company, eventually sends them a cease and desist letter. And the Supreme Court says, among the decisions that an individual may make without unjustified government interference are personal decisions relating to marriage, to procreation, contraception, family relationships, and child rearing and education. The decision whether or not to beget or bear a child is at the very heart of this cluster of constitutionally protected choices. That decision holds a particularly important place in the history of the right of privacy, a right first explicitly recognized in an opinion holding unconstitutional a statute prohibiting the use of contraceptives, Griswold v. Connecticut, and most prominently vindicated in recent years in the context of contraception. Nevertheless, the restriction of distribution channels to a small fraction of the total number of possible retail outlets renders contraceptive devices considerably less accessible to the public, reduces the opportunity for privacy of selection and purchase, and lessens the possibility of price competition. Insofar as the law applies to non-hazardous contraceptives, it bears no relation to the state's interest in protecting health. The statute is obviously not substantially related to any goal of preventing young people from selling contraceptives. Since the state may not impose a blanket prohibition or even a blanket requirement of parental consent on the choice of a minor to terminate her pregnancy, the constitutionality of a blanket prohibition on the distribution of contraceptives to minors is a fortiori closed. The state's interest in protecting the mental and physical health of the pregnant minor and in protection of potential life are clearly more implicated by the abortion decision than by the decision to use a non-hazardous contraceptive. Moreover, there is substantial reason for doubt whether limiting access to contraceptives will in fact substantially discourage early sexual behavior. All right, so that's three. So in the 70s, they established a very strong right to contraceptives, um, even to unmarried people and to minors. And they even put in that part that the state cannot put in a requirement saying that you have to have parental consent for an abortion, or for contraceptives. Okay, I'll see you for the next one. We'll be talking about Roe v. Wade and Dobbs. Have a great day.